please, please feel free to turn off your cameras. Okay, also we have a chat function, so you can feel free to begin to write your questions in the chat function, and I'd be happy to answer or I'm not going to answer them, but I'd be happy to pose them, or actually we've got a small group, so you can probably pose your question to our speaker yourself. Okay, let me officially begin. Bonjour à toutes et à tous. Je m'appelle Natacha Barth et je suis professeure à la faculté de droit. J'aimerais vous souhaiter la bienvenue à cet événement de la série de conférences Shirley Greenberg. Bien que nous nous trouvions dans un espace virtuel, l'Université d'Ottawa est située sur le territoire non cédé des peuples algonquins. Many of us here are uninvited guests, and I know that I am certainly very grateful to the Algonquin people who are the traditional guardians of this land. And our recognition and acknowledgement of traditional Algonquin territory is not something that I say by rote. I say it in the hope that we will take very seriously its many implications in each of our lives. I'd like to take a moment to introduce our speaker today. Dr. Julie Ada is a Greenberg Fellow and an assistant professor at the University of Ottawa. She completed her PhD at the University of Ottawa's Faculty of Law. She first studied law in South Africa and then completed her first LLM at the University of Cape Town, specializing in international human rights law. She followed this by a second LLM at McGill University, specializing in comparative law. She is the recipient of multiple scholarships, notably the prestigious Bombardier Scholarship and a 3-year Center for International Governance Innovation PhD Scholarship in International Law. Her research interests are in policy reforms and projects that seek to develop strategies to address social issues affecting women and girls, with a specific focus on the intersections of gender, culture, equality, and the law. Dr. Ada's published work has examined such topics as human rights, legal pluralism, harmful traditional practices, and the feminization of culture and religion. In addition to her scholarly pursuits, she practices part-time at a law firm as a family, child protection, and immigration lawyer. Today, the title of Dr. Ada's talk is Exploring the Institutional and Ideological Dimensions of Cultural Violence Against Girls in Nigeria. Specifically, she will discuss the harmful traditional practice of child marriage in northern Nigeria, using a critical legal studies and feminist framework to unpack the institutional dimensions of this practice. So Dr. Ada, we are so happy that you are able to speak with us today. Welcome, and I turn it over to you.
Thank you so much for inviting me here today, and thank you all for joining me. I will just share my screen. Okay, so yes, so as Natasha introduced, my name is Julie Ada. Again, thank you all for joining me. I am very excited to discuss my research on legal development and the democratization of human rights in postmodern Africa. The title of my presentation today is Exploring the Institutional and Ideological Dimensions of Cultural Violence Against Girls in Nigeria. So gender-based violence is a problem that affects women and girls across cultures, religions, socioeconomic class, education, age, and other forms of diversity. It is a human rights issue that manifests itself in physical, psychological, social, and cultural forms. This form of violence has been considered by many to be one of the most pervasive forms of human rights violations, denying women and girls equality, security, and their right to fundamental freedoms. So while my research is relevant to all forms of gender-based violence, I paid special attention to harmful traditional practices detrimental to the health and well-being of girls in Nigeria. So harmful traditional practices basically refers to practices that have some cultural legitimacy, but are believed to be harmful to girls and women. They are very sensitive cultural issues because traditional practices are principles and beliefs held by members of a society for periods often crossing generations. Some examples include female genital mutilation, there's child marriages, there's breast ironing, and also virginity testing. So harmful cultural practices, although classified as gender-based violence, have distinctive features. As previously mentioned, their prevalence commonly hinges on ideas surrounding culture and/or religion. Often these practices are used as justification to the right to practice culture or religion, and they often persist without efficient monitoring or penalty, despite the growing existence of legal prohibitions. Another distinctive feature is the fact that women in these communities work directly and indirectly to sustain these violent practices. So for my research, it was very important to also acknowledge the unique positioning of girls at the margins of age and gender. I consider girls in this context as marginalized within the classification of children as female and within the classification of women as children. The overriding question my research tried to answer was, what are the appropriate legal mechanisms for addressing the incidence of cultural violence against girls in Nigeria? This question has been answered in several ways by several scholars working in different fields. And in recent years, there has been a greater understanding of this problem. Feminists and women's organizations have identified this form of violence as a priority issue. They have placed women's rights firmly on the agenda of international human rights organizations through their advocacy. The discussion ranges from well-written academic research articles to simple calls to actions to end these practices. And these efforts are yielding results. Many organizations, service providers, and policymakers are speaking out about it, both nationally and internationally. However, despite this increased awareness, the problem of violence continues to rise steeply in Africa, specifically Nigeria, which for me was an indication that the problem required attention. So my research could not address every theoretical or practical question pertaining to harmful traditional practices in Nigeria. And so in scoping this research, I decided to focus on a specific form of harmful traditional practice in a single region in Nigeria. I focused on the practice of child marriages within Muslim communities in northern Nigeria, beyond the fact that Nigeria has the largest number of child brides in Africa. Exploring the problem of violence against girls through child marriage was quite significant because I believe this practice fits within the intersections of age, gender, culture, religion, law, and pluralism. Also, unlike other cultural practices like breast ironing and female genital mutilation that are also widespread, but dispersed among numerous cultures, child marriage, although widespread, is also very region specific. Also within the Nigerian state, and more specifically within the constraints of culture and religion in northern Nigeria, child and marriage laws are often used as a testing ground to determine the degree of autonomy for women and girls. Nigerian lawmakers have debated and grappled with marriage customs for decades because religious and cultural groups consistently resist efforts to prescribe child marriage. Professor Sylvester Whitaker, an expert in political development of Africa, described northern Nigeria as a paradigm of confrontation. This is largely because this region has functioned for decades under contradictory institutions without yielding to the modernizing ambition of the Nigerian state. This could be due to the fact that this region also far exceeds that of any other political unit on the continent of Africa, and its population and size also makes it a very dominant political influence in Nigeria. Also, since this region is regarded as a political and geographic heartland of Africa, focusing on the north, for my research, produced an analysis against the backdrop of a detailed account of legal and political institutions and structures that assist in the production and reproduction of violence against girls. So Nigeria has ratified a number of international and regional human rights instruments, providing certain protections for the girl child. Of all these instruments, it is the Convention on the Rights of the Child and the 1979 Convention on the Elimination of All Forms of Discrimination Against Women that specifically recognize the human rights of the girl child. Article 24.3 of the CRC of the Convention on the Rights of the Child uses the phrase traditional practices. It provides that state parties shall take all effective and appropriate measures with a view to abolishing traditional practices prejudicial to the health and well-being of children. The UDHR, which is the Universal Declaration of Human Rights, which has been described as one of the most prominent and fundamental human rights instruments, also provides a general foundation for the protection of girls from all harmful traditional practices. Regionally, there are other influential documents like the African Charter and the African Charter on the Rights and Welfare of the Child, and its accompanying protocol, which is the African Charter on Human and People's Rights, on the rights of women in Africa. These documents have contributed in promoting increased awareness on that gender-based violence is a serious violation of human rights in Africa. So the Convention on the Rights of the Child and the African Charter on the Rights and Welfare of the Child were domesticated in Nigeria through the enactment of the Child's Rights Act, pursuant to Section 12 of the Constitution. This section of the Constitution basically requires all international conventions to be domesticated before they can generate domestic legal obligations. So just to provide a bit of context for Nigeria, Nigeria is a federation consisting of 36 states, relatively sovereign and equal states, with each state having an independent legislature. Governance is shared between three levels of government. There's the federal government, state government, and the local government. Each level of government possesses legislative competence to enact laws within the confines of the legislative list designated in the Constitution. So the legislative list is structured into three categories. The first relates to matters within the exclusive legislative powers of the federal government. The second relates to matters within the concurrent legislative powers where both federal and the state parliaments may exercise legislative powers through state houses of assembly equally. And the third group concerns matters over which only state houses of assembly may exercise authority exclusively. This third group is also referred to as the residual legislative powers. So as previously mentioned, due to the obligations emanating from the Convention on the Rights of the Child and the African Charter on the Rights and Welfare of the Child, the National Assembly enacted the Child's Rights Act. The Child Rights Act is a major piece of reforming legislation enacted by the federal government to address the rights of children in Nigeria. This act explicitly prohibits the practice of child marriage and sets the minimum age for marriage at 18 years. However, child rights matters are residual matters within the exclusive legislative powers of states in accordance with Section 4 of the Constitution. And so before the Child's Rights Act becomes applicable within states, it must be adopted by states through the legislative powers provided in the Constitution. States in Nigeria are not under an obligation to adopt the CRA, the Child Rights Act, and those that have done so by enacting child rights laws have done it at their discretion. So what does this mean for children in Nigeria? It means that children, more specifically girls, have limited rights and protections within states that have not ratified the Child Rights Act. For states that have adopted the Child Rights Act, their legislation sometimes contain different definitions for a child. For example, in Islamic northern states, instead of the minimum age of 18 years stipulated by the CRA, puberty is used as the threshold for ascertaining marriage capacity. Cultural and religious norms are used to justify the change in the definition of a child within the child's rights laws of most northern states. So this problem is also intensified by item 61, schedule 2 of the Nigerian Constitution, which effectively removes customary and Islamic marriages out of the federal legislative competence. And so laws enacted at the federal level will have no effect on the formation, amendment, and dissolution of marriages conducted under Islamic or customary law. Section 277 of the Constitution as well also grants the Sharia Court of Appeal the right to decide questions of personal law for Muslims, including the validity or dissolution of a marriage. This is basically a summary of the regulatory dilemma in child protection strategies in Nigeria. On the one hand, there is a comprehensive piece of legislation, which is the Child Rights Act, which prohibits child marriage and sets a minimum age for marriage. But because of constitutional provisions and the deeply pluralistic nature of the state, the legislation's application is extremely limited in scope. So the story highlighted on this slide is about a girl from Sokoto State in northern Nigeria, married at the age of 8. So Rabi Monday, married at the age of 8, was not told about her marriage until the day of her wedding. She commenced sexual relations with her husband before her period. She did not feel ready for sex. She tried running away to her parents, but they took her back to her husband's house. 5 years into the marriage, she got pregnant. She stayed 4 days in labor at home before being taken to the hospital. Due to the complications, she remained in the hospital for 1 year, going into her 2nd year. She started leaking urine immediately after her delivery. She says once she's able to leave the hospital, she will not return to her husband's home because he abandoned her. So this quote is an excerpt from an interview with Rabi Monday by Annie Bunting in her PhD thesis. So the story on this slide is disturbing to anyone who cares or advocates for women or children's rights. In northern Nigeria, religious group leaders tell their populace that it is an Islamic obligation to wed their daughters before puberty so that they can avoid the social shame associated with child pregnancy. And so girls are frequently married at the age of 13, some as young as 8 or 9, with significant effects, including vulnerability to rape, an end to their education, and other health implications as well. So using the narratives of young girls, academics and sociologists, international and national organizations as well have empirically documented the practice of child marriage in northern Nigeria. These accounts all detail how girls are primed for marriage, how families are arrange these marriages, and with several girls contesting to the arrangement and others conceding, often with reference to culture or religion. So by referencing the experiences of girls, my aim was to move current understanding of child marriage beyond accounts of the collectivity embedded within religion or culture. I argued that girls who experience marriage at an early age speak with a distinct voice to which we should all listen and pay attention to. The voice and experience of girls suggest a specific way of thinking about the problem of child marriage a way that is not over-idealized or over-culturalized or over-religious. Confusion about their own bodies, about their experience of trauma, childbirth, sex, neglect, and abuse are only a few issues I highlighted in my research. A close analysis as well of the experience of child brides revealed how the female body has become a place of production and reproduction of a specific form of cultural, social, and political order. The pattern and consistency in the treatment of gender in this region reveals that ethnicity and other essential identity symbols like religion are used by men to gain and sustain advantage over the social lives of women and girls. The severe health implications for pregnant girls in this area has been heavily discussed in literature. In looking at the health implications for girls, I also noted that I was not dealing with a unitary group of subjects. The bodies of girls subjected to this practice have distinct capacities and properties depending on their age. I also noted that pregnancy-related deaths are known to be a principal cause for mortality for girls in Nigeria. And marriage itself also confers upon girls new and diverse sets of expectations. After marriage, a girl in northern Nigeria can be compared to that of owning a property with excessive limitations placed on her. She's either denied, she's denied her very essence of childhood. From the period of infancy itself, she's then compelled into the stage of producing infants. So as previously mentioned, culture is used as a justification for human rights violations in Nigeria. I use the term culture to underscore the interconnectedness of ethnic and religious identities and the fact that they are equally reinforcing in northern Nigeria. In my research, I realized that the narratives from Islam and Hausa cultural tradition in northern Nigeria are interwoven to reinforce marriage practices. So there, so attempting to distinguish between a religious identity and an ethnic one was extremely challenging and sometimes misleading because religious identity initiates ethnic identity in this context. And so this is why I make reference to child marriages as a cultural practice. As previously stated as well, there is currently no firmness of conviction over the minimum age of marriage issue in Nigeria because of the general perception that Islamic religion sets an age that is below the generally accepted standard of 18 years. This inference has been used to support the marriages of girls as young as 9 years old. At the outset, I also had to concede that certain aspects of religion may work to construct a gendered idea of a woman, but it was also necessary for my research to consider what is meant by woman and marriage within Islamic texts. I found that the interpretation of conceptual terms in the Quran has evolved in a gendered manner in northern Nigeria. As with most religions, it is certainly true that modern Islamic jurisprudence is not devoid of authoritarian misuse and misrepresentation in modern times. And one of such misconceptions is that the Quran permits child marriages because the Prophet Muhammad married a 9-year-old girl. And so religious community leaders in northern Nigeria and parents tell women and girls that the Quran instructs them to be married. And according to Islam, is at 12 years old or 9 years old. So for my research, relying on foundational scholarship by Islamic scholars, I realized that the Islamic rationalization for child marriage has been much debated and accordingly must be understood as a narrative open to many possible conflicting interpretations. I found that there is a lack of consensus even amongst Islamic jurists on whether the Quran in fact condones child marriages. This lack of consensus is because the Quran itself does not set a specific marriageable age for girls. And so those who argue that Aisha was 9, 10, or 13 rely on commentaries used to interpret the Quran. And so I looked at a few of those commentaries and used in interpreting the Quran, using interpreting certain verses in the Quran. Some commentaries put her age at 13, others put her age at age 10. Several liberal scholars in Nigeria, including liberal Islamic scholars in Nigeria, including Masood Oredola in Nigeria, argues that Aisha was in her 20s. So there is substantial literature within prominent Muslim scholars criticizing the origin, history, and content of these commentaries. And so in my research, I argued that reliance on religion by the ruling class in Nigeria is one-dimensional. The authoritativeness of the commentaries they rely on was produced and maintained within a system designed to speak on behalf of women and girls. So reference has not been made to other parts of the Quran or verses in the Quran that contextualizes the idea of womanhood and marriage. And so therefore, rather than the state treating the cause, which is male dominance and class exploitation, religion has been used as an ideological weapon to mask the underlying problem for girls and women. So I argued that the existing legal mechanisms in Nigeria cannot adequately address the problem of violence against girls unless the governance gap within the Nigerian system is properly addressed. The subject areas I looked at, the 4 subject areas within this gap that needed to be analyzed before any mechanism can properly address the cultural environment from which harmful traditional practices emerge include the role of culture, the role of women within culture, the role of the state, and male violence as a particular form of oppression. So as a state party to a number of international conventions, when Nigeria is confronted with its failure to meet certain human rights standards, leaders and other political elites in Nigeria frequently make the claim that certain practices are deeply entrenched in religion and or culture. There is a mystification of culture as something that is ancestral, unchangeable, and a deeply rooted concept. So in this way, any campaign made by women and girls against harmful traditional practices is viewed as a fight against an already established, ancestral, inherited, and consequently unchangeable cultural process. So for the state, since traditional marital obligations fall within the realm of culture or religion, they are unable to intervene or establish limits to the application of these practices within individual states in Nigeria. There is also a tendency to culturalize problems. It's basically interpreting women and girls' subordination in terms of cultural practices that suppress them, rather than looking at external factors like, for example, the economic or political problems women and girls face within their communities. So my analysis revealed how culture is basically selectively used to distract attention from the ways in which social ideologies confronting women and girls are actually shaped by institutional structures in Nigeria. And so an analysis of the context, reasons, and meanings of the use of culture was very necessary to challenge the current dominant versions of culture in Nigeria. So still on the issue of context, reasons, and meanings of the use of culture in defending harmful traditional practices. In my research, it also became quite clear that there is a strong continuity from the colonial to the post-colonial that has resulted in an essentialist understanding of culture. This continuity from the colonial to the post-colonial is basically the conflict between universality and relativism. This conflict is one that reinforces an essentialist understanding of culture and has limited the application of human rights to girls within cultural communities. I discovered that West-centric human rights ideals present serious barriers to constructive cross-cultural dialogue in Nigeria. Much of the debate incited by present-day incidents of harmful traditional practices in Nigeria is often depicted as a conflict between ethno-religious tradition on the one hand and Westernization or modernization on the other hand. Modernity discussed in in opposition to culture is a concept which in African history is connected to the colonial experience and has developed more distinct local features that emphasize the approval or disapproval of certain cultural norms. So there is a genuine sense of moral indignation felt by most Africans over colonial rule and post-colonial Western exploitation. Also because the legitimacy of post-colonial Nigeria and other post-colonial societies' legal framework is largely dependent on international agreements. We see that this process has taken the discussion as well away, or the discussion of rights and protection further away from women and girls who experience wrongs within the community. And so even though Nigeria has ratified a number of international and regional legal human rights instruments aimed at protecting women and girls and children from all forms of violence, progress remains slow, uneven, and too fragmented to actually make a genuine breakthrough in the lives of women and girls. In my research, I found the assumption that women and girls' problems in northern Nigeria are fundamentally problems caused only by patriarchal cultural practices as problematic. This perspective leaves the idea of tradition or culture unproblematized. It buys into an oversimplified, apolitical, ahistorical depiction of culture. The perceived value of present-day cultural practices like seclusion, for example, and child marriage must be understood in light of their historical and structural features and interests. In plural settings like Nigeria, normative orders, including local cultural systems and human rights regimes, present both prospects and obstacles. In the fight for gender equality, legal pluralism also creates a range of complex legal problems in Nigeria. It is often very hard to determine what subgroups' rules are, especially when they're not part of a written tradition. For example, African customary law. Even normative systems like, normative systems with written codes like, for example, Islamic law are often rooted in remarkably different ways of thinking about the law. And so in my research, I argued that one existing dilemma in the enforcement of human rights norms and child protection strategies is centered on the pluralistic nature of the state and the government's inability to ensure a consistent application of human rights and child protection strategies. So the conflict between the need to preserve minority culture and the protection of rights basically forms the basis of how law reform strategies or legal reforms of child welfare legislation have failed to reach the real issues affecting girls in northern Nigeria. So even when discussions deal with local situations, there is an unavoidable conflict between general principles and specific situations within the 36 states in Nigeria. And so the situation in Nigeria could easily be analyzed less on the perceived unchanging nature of culture or tradition, and instead analyzed looking at the tensions between a federal government that envisions a unified modernity and local actors for whom specific histories and contexts are significant. So I inquired further into the selective and self-serving use of the term Westernization as a justification for preserving gender inequality in northern Nigeria. As previously mentioned, since many developing countries and post-colonial times are still subject to political interference and economic domination and control by the West, resistance to this control and imposition is frequently articulated in terms that reproduce problematic essentialist notions of culture. I explored how Westernization is employed to define national culture in ways that insist on a specific form of cultural continuity. My analysis here reveals an image of culture and nation that emphasizes imagined continuities over variation and transformation of culture. And so I drew attention to a specific process called selective labeling. I adopted this phrase from a prominent scholar called Uma Narayan. Selective labeling is a process by which those with societal power conveniently label some changes in tradition as consonant with cultural preservation, while at the same time describing other modifications as cultural loss or cultural betrayal. So selective labeling plays a significant role in facilitating essentialist notions of culture in Nigeria because it basically permits changes that are sanctioned by socially dominant groups to look consonant with the protection of fundamental aspects of culture, while portraying other changes that confront the status quo as threats to cultural preservation. Not surprisingly, the gender of the actors appears to be an element that determines if a specific change is considered an example of westernization that is incompatible with tradition. And so for my research, I argued that selective labeling is at work in northern Nigeria because those with social power tend to disregard or amend custom when it suits them. For example, gender equality and autonomy issues are characterized as Western conceptions by the same groups of people who use the language of rights in arguing for political rights and religious rights as well. Several other examples less linked to gender include ideas originating from the West. For example, the basics like using computers to cars, to constitutions, all of these are embraced and modified for local use in Nigeria without generating a discourse that frames them as symbols of westernization. But other borrowings are seen as problematically Western when they affect women and girls. And so I argued that what counts as westernization is very specific. Modifications affecting women and the family are more controversial than transformations with respect to men in the public domain. So moving on to the role of women, I already highlighted that men are dominant and have superior status in the private sphere, and that control is a key motivation for child marriage. Since superficially, it may not be in the interest of women to discuss this mechanism of control, basically women's role in reproducing violent practices. It is easier for me, at least, to keep a clear conscience by focusing on external factors like poverty, education, male sexual violence, patriarchy, or health. All of these factors that rationalizes the persistent oppression of girls. However, I found it important as well to appreciate how power is brought into play in the context of mothering. Women are not passive victims in harmful traditional practices performed on girls. Women reproduce male domination through actions towards girls. That is in referencing their roles in female initiation ceremonies, marriage ceremonies, their control over their granddaughters, daughters-in-laws, younger co-wives, and so on. So practices like breast ironing, female genital mutilation, forced feeding, virginity testing are generally spearheaded by women. For example, it is women whose breasts have been ironed that actively participate in breast ironing, and it is circumcised women who actively participate in genital mutilations as well. So women are frequently active campaigners of cultural practices, arguing for them, conceiving them as being in the interests of children, as members of cultural communities. And so I thought it was important to analyze the role of women in the reproduction of cultural practices. This was necessary because I consider criminal justice reform as a vital component of efforts to reduce cultural violence against women and girls. But criminalization itself may have a disproportionate impact on women within these communities. My focus on mothers was also to understand how oppression is produced and reproduced among people in very close relationships. I found that mothers in northern Nigeria suffer from a duality. They battle over the choice of following cultural practices or cultural prescriptions, or having choices or between speaking out against violence or being silent, between being active, being actors or spectators as well. Women often choose the safety of conforming to, with their present state, to the possibility of a world free of oppression for their children. And so before recommending criminal reform, I had to pay attention to the dilemma of determining the moral responsibility of mothers who support and participate in violence against girls. So despite the role of women in culture, I also noted that women do not exist in isolation. They exist in constant interaction with legal and political institutions. For most women in this context, oppression is systemic and institutionalized. There are institutional factors inhibiting women from fighting to transform their reality. These factors must be recognized to challenge the status quo. So in this section, I argued that despite the range of cultural factors that play a role in sustaining child marriage, there is little reason why child marriage remains unregulated in Nigeria. Abdullahi and Naim, a professor and a prominent scholar, Islamic scholar, notes that the state, in its juridical sovereignty, extensive powers, and relatively much larger resources, is a key element in the context of cultural transformation. In Africa, scholars argued that the current failings of pluralistic African states, specifically in the realm of law, rights, and development, is a creation of colonialism and the legacies given to African states. This is largely because the systems established under colonial rule were simply continued after independence, but only a poor copy, because African states generally lacked the administrative and political means to sustain these structures. So there are many features of Africa's political and legal framework which do not correspond to pre-colonial versions of law or politics. So for my research, it was important to determine whether the Nigerian state's failure to protect girls within these communities is simply a passing condition as a result of colonialism, a transition, or a temporary limitation in legal development of the state, or whether it was signaling something more permanent. My position here as well was premised on the fact that many of the major abuses against girls and women within culture often occur as a result of political and legal institutions. And so I argued that instead of seeking an explanation that only assumes a defectiveness of culture or religion, conceptual practices of power visible within political and legal systems had to also be analyzed. I also analyzed the capacity of law to validate dominant social and power relations in ways that come to be seen as normal and unchanging. I noticed that laws tend to romanticize women's lives and their roles in the family while according men significant power. Policy at the federal level appears accommodating to the interests of women with the inclusion in the Constitution of sections prohibiting sex discrimination. However, this has to be related to other aspects of law associated with the control of women. I highlighted a few examples from the Police Act on the PowerPoint slide. Gendered provisions like within policy regulating the police force, for example, evidences a specific ideology that encourages an intense disregard for women's experiences while privileging a masculinized way of knowing. The constructions of gender in this act, for example, facilitates a specific idea of womanhood and an idea that also shapes the experiences of girls. So even though the Police Act has no correlation with the practice of child marriages, its approach shares a presupposition represented as part of an active process of dialogue between external and the internal. Other gendered provisions I highlighted includes Section 55 of the Labor Act, barring women from employment at night. Laws like this, like the Labor Act, generates several frameworks and hierarchies of workplace rights, which can easily be manipulated to the detriment of women as well. These are just a few examples. In my research, I did highlight a few others. Finally, I also argued that the social and cultural environment in Nigeria is male-dominated. It's male-centered and male-identified. I showed how the Nigerian society is organized around male needs. Reality is seen from male perspectives. Male attributes are considered more valuable, and they dominate in culture and politics. I argue that one of the main roots of child marriage in Nigeria is male sexual violence and male abuse of power. Girls are celebrated as young wives and mothers, not as children. Also, the sexual violence experienced by girls in early marriage is arguably the most severe level of violation experienced by these girls. To me, this is the most horrific aspect of this practice. A 10-year-old girl's body is not suited for pregnancy and childbirth. And so to create a legal system that is responsive to women and girls' experiences, I had to focus on male power and locating that power within a patriarchal order that is deeply misogynistic. Men's physical power over girls is also reflected in the fact that adult men feel entitled to rape their wives, even though they are children who are physically and psychologically unready for sex. It is one thing to be forced to do domestic work in your husband's home, which is another form of violence and causes other kinds of harm, but sexual assault itself is an extreme form of violence and creates a serious form of lasting physical harm and trauma. Certain other cultural practices in northern Nigeria, like street hawking, are risky for girls, but many 10-year-olds within this context may be ready for it. But I don't think any 10-year-old in any context is ready to be is ready for violent sex anywhere in the world. Yeah, I'll just move on from this topic. And I want to just briefly highlight an overview of the legal theory and research methodology I used for my research. The complexity of the issues addressed in my research required a variety of theoretical tools. My choice of theory and methodology was informed by the aspect of child marriage that I wanted to unpack. I used a feminist perspective because it necessitates a clear understanding that being a girl in Nigeria has political consequences. It may seem unclear how a discourse originating from a concern with the condition of women in the most developed societies will address the female collective in northern Nigeria. I must acknowledge that aligning the experiences of African women and girls with analytical debates or dictates of feminist theoretical frameworks is a challenging experience, even though recent scholarship has tried to address specific exclusions within many feminist projects on African women. More subtle forms of exclusion still plague the feminist knowledge base on African women. And so adopting feminist theories to the complex nature of social relations in post-colonial Nigeria is difficult. However, postmodern theory provided an opportunity for the voices of excluded groups and the diversity of women and girls' lived experiences to be heard. So I use postmodern feminism. Postmodern feminism denies universality and emphasizes cultural specificity. I relied on the version of postmodern feminism adopted by Ben Habib that substitutes universal notions of women with plural constructions that treat gender as only one factor among many, while paying attention to other factors like race, age, ethnicity, and other factors as well. So this position was quite crucial for my research. The problem with universal notions and generalizations of girlhood is that it sometimes inhibits a full understanding of the voices of girls within specific political sites. I could not begin to speak about solutions to the problem of violence against girls when the diversity of voices and the lived experiences of women and girls in Nigeria have not been fully explored. I am sure you can all tell by now that the relationship between colonialism and modernity in Nigeria was a recurring theme in my research. Postmodern feminism does not adequately interrogate the colonial trappings on which law is based, which continue to exploit women and girls. Also, it does not sufficiently address the ways in which the colonial past continues to influence the post-colonial present. So for my research, it is precisely here that the emancipating potential of a post-colonial feminist theory lies. So post-colonial feminism is basically a critical approach focusing on colonial legacies and their enduring effects on women and girls. This theory explains women's subordination, women's conditions of subordination within the conditions of postcolonialism. It basically encourages the view that the problem of gender-based violence should not only be seen as a problem of inequality or human rights protection, but also as a problem that goes much deeper historically and politically. And more specifically for me, it was important to keep in mind postcolonial critics that recognize the need to not only look backwards toward the past, but also pay attention to the seemingly harmless aspects of colonial discourse and structures that have survived the formal end of colonialism in Nigeria, but still persistently exert much influence in today's culture, politics, and law. Like many scholars, I also wondered why numerous institutions and legal structures inherited from the colonial past did not work in most African states. And so I could not ignore the significance of the colonial encounter for the situation of girls in the post-colonial world. I also looked at critical legal studies because the ability of the law to add value to the legal development to legal development in Nigeria was a key theme in my research. A fundamental concern in critical legal studies is the need to unravel the ideologies of legal institutions. Ultimately, I wanted to reveal the ways legal ideology has facilitated the creation, sustenance, and legitimation of violence experienced by girls in Nigeria. And so using critical legal studies, I was able to show how law advances specific interests and legitimizes existing social structures and class relationships. Finally, since legal studies holds that law is inherently contradictory and is largely a product of dominant social groups, I believe that the expressions of law can be best analyzed through texts, legal and non-legal texts. So these texts could be in the form of literature, the news, political debates, films, and adverts. The procedure used in gathering text for my research was Dorothy Smith's feminist socio-legal methodology, more specifically textuality as a method. It is important to note that my work was merely a partial representation of Dorothy Smith's methodology. Her methodology is institutional ethnography, which, although focusing on institutions and not individuals, is designed in such a way that conducting empirical research is a vital element. I did not engage in a full institutional ethnographic research. In my research, I thought of texts as discourse, basically texts as a part of a combination of separate texts which also echo each other, and in which cultural attitudes, gendered identities, and specific ways of knowing and seeing and thinking are recreated and continuously constructed. So the goal of my research wasn't simply to provide a descriptive analysis of the problem of child marriages in Nigeria. Instead, I focused on exploring the numerous contradictions and tensions around national and local politics, the westernization of Sharia, universalizing strategies of the human rights framework, and how they exclude the lived experiences of girls in northern Nigeria. So by displaying child marriage as a prolific site of historical, religious, and political struggle, my research tried to draw attention to the shifting national and local politics of regulating this practice. And so based on that research, I was able to suggest specific areas for law reform and certain community level services and support groups for women and girls in northern Nigeria. So this concludes my presentation. Thank you all for listening.
Thank you so much, Julie. That was a really excellent presentation. This is such a fraught area of research, maybe especially for feminists, because of, the treatment of Muslims globally, colonialism, who speaks for whom. But, your presentation, and I can say this especially because I've read Dr. Ada's wonderful thesis. It's so thoughtful and sort of nuanced in the way that you approach this really difficult topic. So let me open it up for questions. And I see that Signa, you have a question.
Hi, and great to meet you, Julie. And I absolutely promise I'm not wearing army fatigues. This is tie-dyed. I'm just looking at it right now, and I'm making an image that I don't want to make. I am so intrigued by you bringing up that concept of selective labeling, because I think it's such a great term for all of us to learn about or be reminded of, to watch out for in whatever we're learning about. And I heard you mention another term that I really struggle with whether to use anymore. So I'm wondering if thinking about selective labeling has impacted how you think of the following term. And it is this: customary law. Because sometimes I have a big urge to just say, gall darn it, that's law. And whenever I hear people using it, I shouldn't say all the time, but I've often heard people use the concept customary law, and then as an effect, they're thinking of it as an area that's an alternative or an area they ultimately won't know about, but there's still this other format to go to. And I was just wondering if in your own interaction with that sort of label, that sometimes you find yourself supportive of who's using it, but maybe are there moments where whomever is using it, you're fearful that what they're describing might be brushed aside? Anyway, that's just what I was thinking about during your presentation. Thank you, and great to meet you.
Thank you so much. Great to meet you as well. So that's a very great comment from you, because I think when we label customs as customary law, there's a certain hierarchy that comes into play when you compare whether it's state legislation versus African customary law, for example. So from that angle, the labeling is quite problematic, because then we're putting other laws above other normative systems. However, even the term law itself, some scholars in Africa find that problematic, because what is law? When we think about law as it's written in texts. And when we think about customary law, we're thinking about societal practices that tend to evolve sometimes faster than legal texts are amended. So on the one hand, sometimes I'm supportive. On the other hand, sometimes I find using the label customary law as well beyond customary law, just using the label law itself as being problematic for normative systems.
Thanks, Julie. Vanessa, you had your hand up.
Hi there. Thanks so much for your presentation. It was really interesting. And I want to ask a little bit about some of those law reform suggestions that you talked about at the end. And I know that you said that that wasn't your focus, so I want to be fair. One of the things that really strikes me about your presentation today is like some of the real challenges you present in terms of thinking about what women-led law reform might look like. And in particular, when you were talking about the challenges of mothers and of grandmothers, this idea that there is a real kind of social pressure or felt need to socialize children or girls, or ensure that they're participating in certain practices, because there's a sense that it's risky for them not to be. And in some ways, what I hear is coming out as like this really complex picture about, the types of factors and forces that women at all stages are navigating. And I think that really comes out of your, talking about the role of culture and the role of law. And I guess I just am wondering for your thoughts about, what that means for law reform then, because it just seems complicated, like navigating all of that. It seems like it has to be a really delicate process for women who, are pushing these issues forward or want to think critically about some of these practices.
Yes, thank you so much for your question. So in terms of law reform, I did push forward the idea of setting a minimum age for marriage. I acknowledge that the problem of child marriage may not be resolved by adopting simplistic solutions, such as prohibiting marriages concluded below a minimum age. But I also argue that it was necessary. It was a necessary step. So I suggested that Section 21 of the Child Rights Act, which sets a minimum age at 18, be amended, because given the social context for girls in northern Nigeria, I believe that the sensible legal course would be to reduce the minimum age of marriage to 16 years old. This would be an absolute minimum age below which nobody or no girl should marry. Regional legislatures may set a minimum age higher than 16, but federal law needs to establish an absolute minimum age. However, I also realized that in my research, I had to confront the duality that women experience. I am not recommending for the imprisonment of family members who pressure girls into marriage. Sending parents, siblings, extended family members, or grandparents, for example, who encourage child marriages to prison may drive the practice underground, which would be beyond the reach of law. So girls may also want to protect their family members and not seek assistance from the state or the police because of criminal consequences for their mothers. And so considering the overall social impacts on families and children, I was only advocating for the prosecution of men who marry children. So regarding mothers who support and participate in harmful traditional practices, a contextualized analysis leads me away from the tendency to prosecute them criminally. And so I argued that because in the Child Rights Act, there's a penalty, it's actually criminalized as well, including family members. So I argued that the Child Rights Act should be interpreted to exclude women who promote child marriages in general, because we need to refocus our attention on the men responsible for these practices instead of blaming women whose lives are also deeply constrained by the society they live in.
Thanks, Julie, for a great response. Sylvia.
Hi, thanks, Julie. That was super interesting. And it's not I don't do international law. So this is, I'm out of my depth here, but so excuse me if my question is sort of facile or ill-formed, but you mentioned towards the end when you were talking about the kind of the theoretical influences of your project, you talked about postcolonial feminist theory, and you said something that I thought, just a phrase that struck me, that it denies, I think you said, it denies universality and it emphasizes specificity, which I think is obviously makes a lot of sense and is important in this kind of plural framework. But I wonder, is there a tension between that on the one hand and this idea of a kind of moral realism that you're employing, where you're kind of denying cultural relativism's claim maybe that every culture and every community gets to make up its own moral norms and can't be analyzed from without, right? Which I'm very sympathetic to. I'm also a moral realist, but is there a way in which that idea of denying universality and emphasizing specificity is intention, or do those in fact work together? And I wondered if you could comment about that, about looking at outside of, or into different cultures and this idea of post-colonial feminism.
So that's not something I've considered deeply, but it's a very interesting question. But I think from my research, if I understand your question clearly, I think it's something that can actually be reconciled together. Because for postmodern feminism, I think it's not just focusing on a specific cultural context and just taking the information you receive as is. There's room for analysis, there's room for balancing whatever information you receive with human rights norms, for example, or other generally acceptable norms in society. So the relevance of postmodern feminism for me in this research was just the specificity that was required in terms of history, understanding the history, understanding the context. That way, even though I suggest legal reform that is more Western oriented, it makes sense and it's logical because I've actually understood the context for which I'm asking for it to be applied. Because I think one thing I've discovered is that when it comes to scholarship, looking at different contexts, the results of those scholarships tends to be questionable when you fail to understand the lived experiences of those in those contexts. So I wanted to avoid transposing ideas from the West without understanding the situations of women and girls.
That's perfect. That actually totally answers my question, and I appreciate that. Thank you.
Thank you.
Susan A., you have your hand up.
Thank you very much. Can everyone hear me? Hi, can you hear me now?
Yes, we can hear you. Sorry, we were nodding our heads.
Oh yeah, no problem. Hi, Julie. Thanks so much for the presentation. I really, really enjoyed it. I'm in the course of my own PhD program, so I'm very happy to be here today. Very thoughtful things to take home for me. Yeah, and congratulations for completing such an important research. I just wanted to take you back to the role of women for a minute. I was wondering, have you considered the place of social movements in the reform process? Because I can't remember specifically what gender issue came up in Uganda, but when the reforms were proposed in the bill, it was women that came out agitating against it. So we see that most of the times laws don't just work, right? Especially when culture is involved. So I was just wondering, is there a place for social activism in this kind of reform you're looking at? Thank you.
Thank you so much for your question. So yes, certainly, the role of social movements was not really the focus of my research. So I didn't really focus on that aspect. However, in adopting social service initiatives in my conclusion, based on the information and the research I did so far, I realized that NGOs, I acknowledged the advocacy work done by NGOs and other social groups in Nigeria, because these groups are actually well placed to promote and encourage sustainable cultural transformation for women and girls in societies. So certainly social movements and social groups have been doing the work. They're doing long-standing work in northern Nigeria, work that I myself from here writing and researching have not been able to do. So my research was basically more to complement or add on to the works of social groups currently present in northern Nigeria and other regions in Nigeria as well. But no, that wasn't the focus of my research. And so I didn't really go in depth to see the types of the relevance of social movement for harmful traditional practices.
if there are any other questions, otherwise I have one. Okay, I found your work so helpful in thinking about an issue in the context, in the Canadian context. So in the Canadian context, a few years ago, the Conservative government enacted the Zero Tolerance for Barbaric Cultural Practices Act. So very problematic piece of legislation. But one of the things they were trying to get at was the issue of forced marriages. In Canada generally, but clearly they were thinking about certain cultural communities. And I've just found your work really helpful in thinking about how to navigate, this really fraught area. And I'm wondering, you don't need to comment on the forced marriage context in Canada, but whether you think your research has implications for how we might manage certain issues in the Canadian or North American context.
Yes, so thank you for that question. I think it does have implications, but maybe more specific, because obviously contexts are very different and the information produced in my research is very specific to Nigeria as a whole, but more specific to Northern Nigeria. However, I think the theories that I used, specifically postmodern feminism and postcolonial feminism, are theories that I think can be used and reapplied into any context. So for example, looking at forced marriages in Canada or the Zero Tolerance Act, I find even just the labeling of the act to be very problematic to many cultural communities, just looking at it through the lens of postmodernism or postcolonial feminism. Using those theories, I can see how any researcher should be able to analyze any issues affecting cultural communities, cultural or religious communities, using those specific tools. But I always argue or warn against transposing ideas that may have worked in other contexts to any context, but the tools itself remain relevant.
Great, thanks so much. Are there any other questions or comments from anyone? Okay, well, this was a really wonderful presentation and a great group of people to be listening to your presentation. Thank you so much for all of your willingness to engage in dialogue with Julie. Julie, thank you so much for your amazing work, and I can't wait to see what you're going to do next. Thanks so much, everyone.
Thank you. Bye, have a great day.